Coming up next on Arizona Horizon, the United States Supreme Court session began this week and the High Court is already making big headlines. We'll get a preview of the session with ASU law professor Paul Bender next on Arizona Horizon.
Arizona Horizon is made possible by contributions from the Friends of Eight, members of your Arizona PBS station. Thank you.
Good evening and welcome to Arizona Horizon. I'm Ted Simons. The U.S. Supreme Court's new session is underway and the assembled justices wasted no time in reshaping the debate over same-sex marriage. The High Court is set to take up a variety of cases this session, including 2 from Arizona. Here with a preview of the always eventful Supreme Court session is ASU law professor Paul Bender. Good to see you. I say always eventful. Is this going to be an eventful session?
Always eventful. It's not going to be as eventful as people thought it was going to be, because almost everybody thought they were going to take one of the gay marriage cases. And then that would have been the signature event of the term, and people would have talked about it all term, and it probably wouldn't have decided it till the end of the term, but they decided not to grant certiorari. So even when they don't do something, it's a big event. But it's interesting to think about, why did they do that?
Why did they do that?
And especially when you're thinking about that, you should bear in mind what the result or the effect of them denying cert in those 5 cases. They had put on hold the decisions in those 5 cases permitting gay marriages to go forward in those states. That stay lasted until they denied cert. So as soon as they denied cert, they knew that gay marriage was going to expand pretty dramatically to all the states in those 3 circuits. That's a lot of states.
Right.
So can you do that and still think that there's a possibility that you would ultimately hold that it's constitutional to ban gay marriage? By the time they get around to it now, it'll be a year or 2 from now, 90% of the country will live in states that permit gay marriage. So I view that denial as basically raising the white flag by the people who are opposed to gay marriage. And we know there are 4 people on the court who think it's constitutional to ban gay marriage: Scalia, Roberts, Alito, and Thomas. Now, they could have granted cert, because it only takes 4 votes to grant cert, but they didn't. Why didn't they? Because they don't have a 5th vote. And if they don't have a 5th vote now, when are they going to have a 5th vote?
And that 5th vote would have been, of course,
would have to be Kennedy.
With the Kennedy, right. And yet Kennedy went ahead and temporarily blocked. So what did he do,
and
why did he do it?
I think that makes sense, because there's no circuit split. That's the one time the court will have to take that case. The Ninth Circuit held the way the other circuits held, that bans on gay marriage are unconstitutional, but the losing parties in those cases, those 2 states, can go to the full Ninth Circuit and ask for en banc review, and they could get that. And if the en banc Ninth Circuit were to hold that bans on gay marriage are constitutional, then there would be a split in the circuits. And I think it makes sense for Kennedy to give them time to ask the circuit whether they want to take the case en banc. Because if they do want to take the case en banc, I think it would make sense to hold up until they decide, because you don't want people getting married and then a year later say, hey, those marriages are invalid.
Right.
That would be just terrible. So it makes sense to me to have him give a state, to give them time to go to the Ninth Circuit for rehearing en banc. To give them time to file a cert petition doesn't seem to me make sense, because they just denied cert in this issue.
Yeah.
So I assume that's what he's doing, that he's giving them enough time so that they can file a rehearing en banc petition before the Ninth Circuit. And so that if the Ninth Circuit wants to take this case, they can take it without the decision going into effect.
Have they refiled? Do we know what the Ninth Circuit's going to do?
No, we don't. I think they've already asked the Ninth Circuit, but the Ninth Circuit hasn't done anything, and it probably won't for a while. To grant rehearing en banc, you need a majority vote of all of the judges in the circuit, and that'll take a while to circulate around and get the vote. If a majority of judges in the circuit vote to rehear it en banc, then they pick 11 judges out of the 20 odd that they have. And those 11 could be tilted one way or another. It's all random. And so it's not inconceivable that the Ninth Circuit would grant rehearing en banc, would reverse the panel decision, uphold the bans on gay marriage. If they did that, then the Supreme Court would have to take the case. But that'll be a year from now. And meanwhile, gay marriage will be the law in all those states, in all the circuits that they just denied cert on the other day.
And it seems like we kind of know what the court is going to do.
You would think so.
Yeah.
It's hard to imagine one of those people like Kennedy changing his mind in the next couple of years. Why would he do that? if he didn't do it now.
Very quickly, how unusual for a single justice to put a temporary block on something?
That's common for a temporary, just for a couple of days, until he can give it over to the full court. The full court has a conference tomorrow, and I assume Kennedy will present the application for a stay. Now, if the court gives a stay, then it's going to be really confusing.
Yes.
What are they staying? Unless it's just a stay to go to the Ninth Circuit and ask for a rehearing in bank. I don't know if they can do that. They could give a stay pending a cert petition, but that would make no sense.
Right.
So it'll be interesting to see what they do. If they give a stay just for the purpose of a rehearing in bank petition, I don't think that means anything. They're giving the Ninth Circuit a chance to create a circuit conflict. But I don't think, why would the people on the court who just voted to deny cert want to create a conflict so they have to grant cert and then they lose? I'm talking about the four conservatives who want to uphold gay marriage.
Would they just want to have it argued? Would they just want to have it heard?
Why? It would make no sense for them, because what they're going to get is an opinion that they're not going to like. It's going to be an opinion not only about gay marriage, but about the Due Process Clause generally, the Equal Protection Clause generally. It could be a very broad individual rights opinion. Kennedy would write it. He's the senior judge. He would be the senior judge of the people who did it, and he would assign it to himself, and you can never tell what Kennedy will do. I would think they would not. They've lost this battle, I think they realize, and I would think that they would just forget it now.
The time is long gone for sending a message, in other words.
Yeah.
Okay, let's get to Arizona cases. The Arizona Independent Redistricting Commission. This case now, the legislature challenging it. Give us an example of what's going on here and why the court is deciding to get involved.
Well, the why the court is deciding to get involved is a very good question. What's going on is, as you know, the people of Arizona in 2000 adopted a constitutional amendment to take redistricting of both state legislative and congressional districts away from the legislature and give it to the Independent Redistricting Commission. And they have now done, the Independent Commission has done it twice. And the second time was after the 2010 census. And that guided what happened in the 2012 elections. Well, in the 2012 election, 5 of the 9 congressional seats in Arizona are Democratic, and I think the Republican legislature saw that coming, and they fought the Independent Redistricting Commission. They said they were biased toward the Democrats. They didn't like what they did, and so they're trying to get that changed. And what they've done is they've brought a suit saying that it's unconstitutional for a state to have redistricting done by an independent commission. And I would have thought that the court would say, we've already said in 2 or 3 cases that states have a lot of freedom in how they redistrict. There's no conflict in the circuits. Independent redistricting commissions are the wave of the future. More and more states are doing it. It's thought to be a good government thing. It's hard to argue against it, except as for partisan political reasons. Why the court would want to jump into that is very difficult for me to understand.
Isn't the argument, though, that the United States Constitution gives power to draw these districts to the quote-unquote legislature?
Yeah, but what does that mean? Can the governor veto redistricting? Can the legislature give it to, if the legislature redistricts, can the people take out a referendum on that? The court has already said that both of those things can be done. Well, if you're going to give the governor that much power and you're going to let the people overturn what the legislature does, then you're not just giving it to the legislature. And it's hard to think why the people who framed the U.S. Constitution in 1787 would have wanted to say to states, you district, but you got to do it in a certain way through your formal legislature. What would be the reason for that? So it's hard for me to see what the reason would be for the court to take the case to stir things up. If they were to strike down the Arizona Redistricting Commission, that would put a stop to what I think most people in politics think is a really good development, and that is to get redistricting out of the partisan arena, because we know what legislatures do when they redistrict. The first thing they do is save their own seats.
So, but again,
and then they gerrymander
right.
to maximize the strength of their party. That's not a very democratic thing to do.
But again, if the question is the commission allowed under the Constitution, allowed under federal law. You're saying that precedent says...
There's precedent on the Commission's side, but there is language that's difficult to overcome because it says by the legislature thereof.
Yes.
The question is, what does by the legislature thereof mean? The most natural thing, I think, for it to mean is by the normal legislative process of the state, whatever that is. They meant to say, do it the way you do legislation. And I think they meant to say, don't have the governor do it. That was why it said legislature. Otherwise, do whatever you do. And that's what the language in the Supreme Court's opinions in the old cases that uphold letting the governor veto it and letting there be a referendum say, well, that's the normal legislative process, so that's okay. And that makes sense because what the framers were doing there was to say the states should draw the districts unless Congress wants to take it over. Well, if you say the state should draw the districts, why shouldn't it be up to the states to decide how they're going to do that?
Right.
If the people of the state want to do it one way, why would the Constitution of the United States stop the people of the state from saying how they want to district their states?
And if you're saying that if the people say we want a commission to do it, then that falls under the umbrella.
Exactly. And it would be especially ironic for the Supreme Court to say the people cannot get the districting with congressional seats away from the legislature, but they can get the districting of the legislature away from the legislature. You would think if the people could do that, which they clearly could, there's nothing in the Constitution to stop that. It doesn't make any sense.
Any idea where the court's going to go on this?
Well, the fact that they took it creates doubt in my mind. They didn't have to. But when I think about it, I say to myself, is it really plausible that they will stand in the way of this development nationwide to get redistricting out of the partisan arena? It troubles me because it's one of several things the court's done recently that really seem to be done for partisan political reasons. That is, Republicans versus Democrats, rather than for principal reasons. There are a couple of cases in the last week where they've stopped voting changes from going, which were going to help minorities in voting, and which the Republicans were against and the Democrats were for. The court stopped in and gave stays to keep the thing in a way that the Republicans wanted. If that's being done for political reasons, that's very unfortunate.
Another Arizona case, 2 Arizona cases this session.
Yes, right.
The other involving this church sign ordinance in Gilbert and the idea of a city or a town being able to put into ordinance nonprofit signs. You can't do this, you can't do that. This has made it to the Supreme Court.
Yeah, that's also surprising. But it's there for a technical reason that's important. In the law of the First Amendment has grown up a doctrine that it makes a difference whether when you restrict speech, you do it on the basis of content. If it's a content-based restriction, then the court applies strict scrutiny. You need a compelling interest, and it has to be narrowly tailored to serve the interest. If it's content neutral, then the state has a lot of latitude. The question in this case is, there are 19 different kinds of signs that you can put up in Gilbert without a permit. Okay, the church comes under temporary event signs. Those have to be, I think, 6 square feet maximum, and they can only be put up for a day before the event. They have to be taken down right after the event. Political signs for political candidates can be 32 square feet, and they can be up unlimited time before the election. So the argument is, hey, that's a discrimination against the church's signs. If it's a content discrimination, the city has to show a compelling reason to do that. I don't think they can. If it's not a content discrimination, then the city can say, well, you know, we just decided this was a reasonable thing to do, and they normally can get away with that. So the question of whether that kind of difference, not content in the sense of viewpoint, that is, it's not favoring liberals over Republicans or over conservatives the other way around, but it is content-based in the sense that what's your sign for? Is it for a political campaign? Then it can be a big sign. Is it for an event that's temporary? Then it has to be a little sign. That's content, but in a different way. So what the court ought to do, in my view, is say that's not content-based. There's no reason to have strict scrutiny of that kind of decision because it doesn't threaten to harm anybody because of minority status or their political views or anything like that. And so they ought to have the latitude. But this court has been very tough on First Amendment cases, and it wouldn't surprise me if they held that that's content-based, and the city has to have a really strong reason to do that.
I noticed at the Ninth Circuit that the three members split in favor of the town, but there was a split there.
There was a split, yeah, that's true.
Does that surprise
it's a
you?
No, it's a very difficult, contentious issue all around the country. How do you define content-based for First Amendment purposes? And it makes a big difference, because content-based things tend to be held unconstitutional, and content-neutral things tend to be upheld.
All right, and not the only free expression case I can think for the court. We have a couple of them, Elonis versus U.S. and Yulee versus Florida Bar. Very quickly, what's going on with these cases?
They're both really interesting. The first one, Elonis, involves when you can convict somebody for threatening. Elonis broke up with his wife and was in bad shape and started posting things on his Facebook page which were threatening. A lot of them were just rap lyrics, threatening rap lyrics that he quoted there. But they seemed to say to his wife, "I'm going to come and get you." And so he got prosecuted under federal statute, which makes it a crime to threaten people over the internet and other things like that. He says he didn't really mean it as a threat. He was just letting off steam. He was venting, as they say. The judge told the jury, if a reasonable person would think that that was a real threat, then he's guilty. He says the judge should have told the jury, you can only convict him if the jury believes that he intended it to be seen as a threat. And the lower court said they don't have to prove he intended it. They just have to prove a reasonable person would think it's a threat. And the court took that case. So the court, again, seems to be winding up maybe to be a very strong First Amendment case and to free a whole lot of threatening stuff that you would think ought to be able to be stopped.
Including knowing the intent of someone who's putting
How do you do that?
Yeah, that's what I was going to ask.
So that surprised me that they took that case. The other case involves judges who run for election. A number of states elect judges, and that's a problem. Because when you run for election, you have to raise money. Who do they raise money from? They raise money from lawyers. Well, who do the lawyers go before to get their cases decided? The judges they just contributed to or didn't contribute to. So these states have said, it's not a great solution, but they've said that judges cannot directly solicit money. They can't go to somebody and say, please give me money. They can appoint a committee to do that, but the judge shouldn't do it himself. This judge signed a fundraising letter. It wasn't a judge, he wanted to be a judge, it was a she also, signed a fundraising letter. And the question is whether you can be censured for that kind of free speech. And the lower court said yes, and the Supreme Court takes that case. So it sounds like they may be saying that it's unconstitutional for a state that elects judges to put limits on how the judges can campaign and how they can raise money.
Oh,
because
goodness.
The court has held several times that raising money for campaigns is free speech.
Yeah. And as well, we mentioned the Gilbert Sign case, religiously focused, if not targeted. But a couple of other religion ideas here, Holt v. Hobbs and EEOC versus Abercrombie and Fitch. These kind of deal with religion in terms of Muslims and how they practice their faith.
They both are Muslim cases. The Gilbert case is true. It is a religious group that wants to put up the sign, but I don't think the religious nature of it has anything to do with it. But Holden Hobbs is a Muslim who wants to grow a beard in prison, and most prison systems permit that for religious reasons, and he wants to do it for religious reasons. Nobody doubts that there's sincere religious reasons, but the state doesn't want to let him do it. He offered to compromise. The religion tells him he should grow a beard. He said, I'll keep it a half-inch beard, which seems to me weakens his case some, because if it's his religion, what's he compromising about? I think Scalia said something at the oral argument about that. But the state says, no, it's going to be dangerous. Well, this is a case applying essentially the same statute that was involved in the Hobby Lobby case last year, RFRA. This is the prison variety of RFRA, but it's the same standard. If you interfere with somebody's free exercise of religion, you have to have a compelling interest, and you have to what you do has to be as narrow as possible to serve that interest. So the issue in this case is, does the state have a compelling interest to stop him from growing a half-inch beard? Well, why is a half-inch beard dangerous? You can't hide very much in a half-inch beard. And the state has come up with a number of reasons, none of which sound very plausible. The case was argued, I think, yesterday or the day before, and the court did not seem to be very friendly toward the state's
not
argument.
too impressed.
So here is a case where, and maybe they're sort of embarrassed into it, having held that a business owner can impose his religious views on his employees in the Hobby Lobby case. Here is a Muslim who has religious views. Are they going to say, sorry, you can't exercise your religion in prison when they don't have a really good reason?
Which brings up that Abercrombie and Fitch story. Talk to us about that case.
That is a Muslim woman, young woman, who wants to work in Abercrombie and Fitch. Have you been in Abercrombie and Fitch
A long
stores
time
lately?
ago, yeah.
They have a dress code.
Oh, really?
Which says you got to dress in the kind of clothes we sell.
Oh, okay.
That is like Eastern collegiate wear. She wears a headscarf. So she asked a friend of hers who worked there, do you think my headscarf is going to be a problem? And the friend asked a supervisor who said, no, that's no problem, as long as it's not black. They don't like black clothing. You can't wear black things.
Not everyone looked better in black.
So she interviews for the job. The person who interviews her grades are very high and says she should be hired, but is worried about the headscarf. The woman was interviewed in a headscarf. It wasn't talked about at the interview. So she goes to the district manager and says, what do I do about the headscarf? He says, don't hire anybody who wears a headscarf. So she didn't get hired. The lower court held that that's okay because the woman who wanted employment never said, I need to wear a headscarf for religious reasons, directly to them. And that in order to sue them for religious discrimination, she has to affirmatively say, I need to do this for religious reasons, and say to them, will you let me have an accommodation? And since she didn't go through those steps, then she can't sue. And the court took that case, again suggesting that they're going to hold what seems commonsensical. Everybody knows that she was prevented from wearing a headscarf because that's what Muslims do, and that would be religious discrimination, and they should have to make an accommodation for that.
Interesting. Hey, before we get you out of here, there has been talk of either Justice Ginsburg retiring or, among some, I think mostly Democrats and liberals, that she should retire before President Obama leaves office. What's going on here?
There's a very well-known liberal constitutional scholar has written an article saying she should retire, because he says if she wants her legacy to continue, she should do it now so she'll be replaced by somebody nominated by Obama, who would probably be somebody who would vote like her. Whereas if she waits, Republicans may win the next presidential election, and then she would be replaced by somebody who was of different views. And a number of people have said that. I think that's completely wrong. And I think she is right not to listen to that stuff. When you have judges deciding when they're going to retire based on keeping their views alive, you have judges doing things for the wrong reason. They're supposed to decide cases the way they think they are. They're not supposed to be plotting to have their legacy be reinforced in the future. They're not supposed to be making political decisions like that.
Has that been done historically, though? Have there been folks who've retired, have calculated their retirements?
I'm sure there have been. You never know for sure, but I think it's wrong. And because you should decide the cases before you. You shouldn't be planning what the court's future is going to be. And I want my cases to stand up and not yours. And she is right not to do that. And she is right now able to do the work. She enjoys doing the work. She does it very well from her point of view, and a lot of people think she does it very well. And she enjoys it. So why should she retire?
All right. We got like 1 minute left now.
Yeah.
That's not much time for this question. Is this still a Kennedy court?
Yes.
It is.
Of course. Yeah, what's changed? It's been the Kennedy court ever since Justice O'Connor left and was replaced by Alito. That meant that there were 4 strong conservatives, Alito, Thomas, Scalia, and Roberts, and 4 moderates or liberals on the other side, Ginsburg and Breyer, and now Sotomayor and Kagan. And Kennedy is the only one who, with any frequency, goes back and forth between those groups. He usually goes with the conservatives, but not always, as we know, primarily in the gay rights cases. But most cases that are close, you say to yourself, it all depends on what Kennedy's going to do. And that has remained the same. That's not going to change.
And does that strike you as being an overtly political court? Is this more political than most courts?
I don't think he is politically partisan in a Republican-Democratic way. I think he's quite conservative, but I don't think he does it as a Republican. I don't know, but I don't think so. But there, I think, are people on the court who see things through a partisan lens. And I think that's one of the explanations for why those four people always stick together, and those people always stick together, because what they stick together on are the agendas of the two major political parties. That is very unfortunate from my point of view.
And it sounds like no one's swaying all that much, are they?
No.
From the four and the four.
Yeah.
It's just watching Kennedy
It
sway.
would really be a good development to get some people on the court who are not allied with either of those groups.
All right. Always a pleasure. Good to have you
Same here.
Friday on Arizona Horizon, it's the Journalists Roundtable. We'll look back on the Arizona Secretary of State debate here on the Horizon set, and a beheading video comes into play in the race for Congressional District 9. Those stories and more Friday on the Journalists Roundtable. That is it for now. I'm Ted Simons. Thank you so much for joining us. You have a great evening.
Arizona Horizon is made possible by contributions from the Friends of 8, members of your Arizona PBS station. Thank you.